So, welcome back. We need to start, even though we are not fully here. Unfortunately, we are running a bit late, so we need to hurry up in order to keep the timeline. Good afternoon, ladies and gentlemen. My name is Giorgi Burjanadze, and I'm privileged to be standing here and to speak and to moderate really interesting session on early access on legal aid. I'm the deputy ombudsperson in Georgia, and one of the things I'm working on is criminal justice and all related work that is related to legal aid and criminal justice defense system. Before working on the Public Defender's Office, I was lucky to work for Open Society Georgia Foundation, where we have worked a lot regarding early access mechanisms. Also, we had a chance to work with UNDP regarding the pilot project on early access mechanisms in Georgia. So we have tried something to develop regarding early access in Georgia, and there has been plenty of work. So we will see in few and upcoming years whether it's really being implemented and whether it's being taken into consideration. For now, it's really interesting for us, Georgia, to see what is development regarding early access mechanisms. So we will have really diverse panel. We will hear different experience from different perspectives. We will hear really diverse dimension. We will speak about the really interesting figures. We will speak about the comparative experience, and we will see how it is being implemented into practice. So I will ask the panelists to speak like maximum 10 minutes. So we need to keep the timeline. We need to be really on time, and we hope to have like approximately half an hour for your discussion. So we hope that you will also have questions, and where panelists will be more able to go into much deeper and to get more information upon your interests. Let me give a floor to the first speaker, Ms. Nora Katona, who is a researcher at the Ludwig Boltzmann Institute of Human Rights in Vienna, Austria. Her work focuses on procedural safeguards in criminal proceedings, as well as prevention of torture and trafficking in human beings. She will, probably we have all heard the project which is called Inside Police Custody. So there has been many research in different countries. We were lucky in Georgia to have the same research. So she will speak about the research which has been conducted in Austria, and we will see what was the developments from there. So, floor is yours.
Okay, so I start without the PowerPoint presentation for the moment. Thank you very much, first of all, for the opportunity to speak in front of you, and thank you for the organizers for this really great conference. I feel very honored that I can start the series of the presentations on the findings of the Inside Police Custody project. I will present the findings in Austria, but there are also colleagues from other countries who are going to have a parallel session in the afternoon. Better? Perfect, thank you. Colleagues from Bulgaria, from Hungary, from Italy, and also from Spain, who are also talking about the findings later on. So I was asked to talk about the early access to a lawyer in police custody. Then the question is, of course, first of all, why is an early access important at all? Okay, I think it should work now. So, of course, we have heard already yesterday that during the police custody, it's basically the groundwork is laid for the further proceedings, especially if there is a protocol or if even there is a confession. These results of the interrogation are going to influence and have a major impact on the throughout criminal proceedings. At the same time, there is also research that an early access to procedural rights is not only an issue to ensure fair trials overall, but and a fair trial in the criminal proceedings, but is also one of the most effective means to prevent torture and other forms of ill treatment. That is also one of the reasons why early access to procedural rights plays such an important role, and why its promotion and protection is so important. So, what is the situation In Austria, basically I based my presentation on 3 findings of 3 projects that we have conducted over the last 3 years. One is the Inside Police Custody project that we have already heard about. Then there was another one which was called Dignity at Trial, where we looked at the procedural safeguards, especially of suspects with intellectual or psychosocial disabilities. And then there is an ongoing project where we explore the role of NHRIs, of national human rights institutions, in the context of procedural safeguards. Since I'm the first one to talk more in depth about the Inside Police Custody project, I just want to give a very quick overview. This research was conducted in 9 countries, amongst others in Austria. So basically we looked at the first 48 hours in police custody, and we had a look on the transposition of different directives and the practical implementation. One of the directives that we had a closer look at was the right to access to a lawyer. What was not included is the right to legal aid. So, of course, since they are very closely connected, we have also findings on that issue. The methodology of the Inside Police Custody project was a little bit, had different components. One was the legal analysis, but we had also a lot of empirical research. For example, we had focus group discussions in Austria. They were a little bit different in each and every country. In Austria, we had focus group discussions with lawyers and police officers. Then we had also interviews with different stakeholders, but also with former suspects. And which was not the case in each and every country, because the access was quite difficult to get, but in Austria we managed to have also observational research, meaning that we were allowed to take part in interrogations at police stations. Unfortunately not to the amount that we wished at the beginning for, but still we had the chance to participate at some of them. And based on these findings, we basically drafted our report. And now I just wanted to talk quickly about the main findings of the Austrian report in the context of criminal defense during police custody. I have clustered it in 3 different parts. The first is the general early access to a lawyer. So basically, there is a right of access to a lawyer in Austria, and it's also foreseen in the directive. There is also the information that has to be provided about this right, which is done in Austria by the police and also in the form of a letter of rights. Then another question that arises in this context is, of course, the effective participation of the lawyer in the interrogation itself. In Austria, that is a little bit more restricted, meaning that there is the possibility of the lawyer to participate at the interrogation, but it is not a very effective way, because the person is not allowed, and the lawyer is not allowed to intervene in the questioning, but is only allowed to ask questions after specific blocks, of thematic blocks. So there is a little bit of a question if this access is really effective in the way as it should be in the context of the directive. Then, in this context, it has also to be said that in Austria there is no mandatory representation at this stage, and so meaning that basically, except for cases when there is the possibility that the person is going to be deprived of her liberty for compulsory medical treatment, there is no mandatory representation, meaning that this right to access to a lawyer can be waived, which is unfortunately a very frequent case in Austria. Also because we, from our interviews, we had the feeling that the police is partly discouraging the suspects to ask for a lawyer, mainly with the arguments like bringing in a lawyer doesn't make any difference, and also bringing in this idea that the access to a lawyer is not effective anyway, which is at least have a chilling effect. But also that for asking for a lawyer will just prolong the time at police custody. Based on the questions that we asked the suspects themselves, they were saying that the main reasons why they haven't asked for a lawyer was really that they wanted to get rid of, they wanted to get out of the situation as quickly as possible, but also that they were afraid that they could not afford the lawyer, which of course brings us also to a very important point of the legal aid aspect. So I just have mentioned the case of mandatory representation, but also here the question is if there is really an effective access to a lawyer is really ensured or not, because we have conducted under different research, basically what I've mentioned before, for persons with intellectual or psychosocial disabilities. And here the question, it was a case that was reported to us. This person has a severe intellectual and psychosocial disability, was summoned for interrogation at the police station when they're alone without any support of a third person. And concerning to sum up what I have said before is basically there is no general mandatory access of a lawyer, presence of a lawyer. There is, of course, a right to a lawyer, but this can be waived, which also in this case happened. And I have mentioned that there is the mandatory representation in cases when there is a chance that the person is going to be deprived of liberty for compulsory medical treatment. But this is only if the vulnerability is identified, which in this case didn't happen, meaning that the person was questioned and also confessed his crime, that he was suspected, but in the end this confession and this protocol was used during the whole proceedings, even though he was not represented by a lawyer, because there is just no effect remedy in this regard, meaning that although there is a mandatory representation, this is only true if this vulnerability was identified. Meaning that if on the question, is there an effect early access to a lawyer in Austria, I unfortunately have to say also regarding the practice, no. Most of the cases are not most of the suspects are not represented by a lawyer during the police interrogation. And in this regard, I unfortunately have to say there is no effective early access to a lawyer in place, although the law would enable that. Then, on the contrary, I have to also to name some positive aspects, which we have. There was a positive development towards a more effective legal representation in the last years by a standby legal concealing service. This concealing service is basically a arrest hotline, to call it like that, which enables legal assistance at the beginning of the deprivation of liberty. It's a 24/7 service where basically the suspect can free of charge call a duty lawyer and ask for the first counsel on his case. Basically, there was a change, and this standby legal concealing advice was implemented in law and enforced in law due to the two directives, meaning the access to a lawyer and legal aid, made it necessary to change the law. So basically, there was in 2017 the legal regulation changed, and it also brought with it that the numbers went up very quickly. So compared to 2016, where there was not yet a legal basis for this standby concealing, it was 409 in total. In 2017, it was already 1,422 cases. So, which is still quite low, to be honest, but still there is a positive development that we can see, and which leads to still the relatively low numbers are that there is still a lack of information, although this information on this possibility is named in the letter of rights, but still we had the feeling from the interviews that most of the suspects have not been aware about this possibility. There is also an uncertainty about the costs, and there are only few lawyers who really take on this duty because of a very not so attractive remuneration. So what I still want to mention is after you have this call, you also have the possibility to ask the lawyer to come to the police station and participate at the interrogation, but this is not free of charge anymore. Which leads me to the question, is this part of the legal aid? Can this be part of the legal aid, this concealing and this being present at the police station? There is until now a legal uncertainty in Austria. There is a different practice depending on whom you ask. Some of them are saying the suspect have to pay the fees, others say the Minister of Justice does, others say the Bar Association need to do that. So there would be it will be very important to have clarity in this regard, also to make legal aid in the context of police custody more effective, and also to be that it is more applied, because until now there is equally to the access to a lawyer, there are not many lawyers present, and also legal aid is not very frequently applied in police custody itself. So that brings me already to our recommendations. Of course, we have very basic recommendations. It would be fantastic if everybody would be represented at police custody, and if possible and necessary, there would be legal aid for everyone. From a human rights perspective, of course, that is our main aim, and that's what we aim for. At the same time, of course, there are also other recommendations which are more easily to transpose and where we already have the existing legal and institutional frameworks. For example, as I've mentioned, you can waive your right to have access to a lawyer. What we very strongly recommend in Austria that you can do this only if you had a first call and talk with another lawyer, and then only you can waive your right, which would be actually not so difficult to implement because we have the frameworks already more or less in place. And the same goes also that we need a clarity about the costs. We need a clarity who is basically paying which fees, because otherwise it is just an aspect which makes suspects a little bit less likely to ask for a lawyer in police custody itself. So basically the way forward is, as we have heard already, the directive needs to be transposed by 2019, so meaning there is a lot of work to do on our national levels. So basically we have our recommendations, and as we have heard, there are these regulations in the directive which are rather vague and give some space for advocacy work, just to put it like this way. So it's very important to build and use this opportunity that in most of the European countries there needs to be the legal aid system needs to be changed in one way or another. And also, which I really liked yesterday, is it was mentioned that we should strive to find new ways how we can work on these topics and these issues. I found it very inspiring. At the same time, I was thinking, are we always really looking for something so new? Is it sometimes enough to look at things with a different approach? I think, for example, also to conclude my part, in Austria, I can say that there are good and really working legal and institutional frameworks, but maybe we just need to explore the possibilities within them more. And also, this brings me to another project which we are currently conducting, is where we are looking what national human rights institutions can do to promote and protect the procedural safeguards. So basically we would we would encourage existing institutions to work more actively, proactively on procedural safeguards. The response of most of them, when we have asked them not most of them, but some of them, when we have asked them to give us interviews and to work together with us in this project, was it's not within our strategic priorities. I think that it's in general something that we have to be very aware that procedural safeguards suspects and accused doesn't have a very strong lobby. And I think it's within our mandate and within our role to make sure that also these rights are effectively promoted and protected also when it comes to the transposition of the directive. Thank you.
Thank you for really interesting presentation. Thank you for keeping in time limit. It was really interesting to hear Austrian example. We will now move to next speaker, who is Dr. Yoav Sapir, who is currently the Chief Public Defender of the Public Defense Office of State of Israel, and we will hear Israeli experience regarding early access. Floor is yours.
Thank you very much. So I guess in this forum, there's no need to emphasize how important is the right to counsel, the early access to right to counsel for the prevention of false confessions, for protecting the rights of the suspect, and for maintaining the fairness of the interrogation. So I'll focus on implementation of this important concept. I think that anyone who's ever represented a client that had not had the chance to meet defense attorney before interrogation knows how prejudicial and irreversible some of the things that happen in interrogation can be for that client. So how do I do that? Back. Okay, so let me start with the bottom line. The bottom line is that we've made a great advancement in the previous years. You can see here that in 2011 we had only 10% of our clients exercising their right to early access. And when I say early access, I do not count meeting counsel in first appearances in court, nor after interrogation. I mean purely meeting the counsel, the defense attorney, the public defender before interrogation. So only 10% of our clients got to exercise this right, and it is a constant advancement, and in 2017 it's almost half of our clients. And I would say a few words about what were the obstacles, why it was only 10%, what did we do in order to overcome these obstacles, and what are the remaining challenges. Sorry. Okay. So here are the major challenges. The first one was unclear rules. So for example, we did have a clear rule that everyone has the right to counsel, and that the police should allow counsel to meet with the defendant, but we did not, promptly, that is without delay, but we did not have any rule regarding when does the police have to inform the suspect of their rights. We did not have a clear Miranda rule regarding that you have to say that you have a right to counsel, and if you cannot afford a counsel, one will be appointed. So that was lacking. Another thing that was lacking is remedies. So I'll talk about it a little later. Second challenge was low compliance by the police, and here we have an inherent conflict of interest. The police officer on the ground, they prefer to question with no prior consultation. So they would try many ways to bypass the right, even when there are clear rules, it's always a problem. One of the things that they would use is, and Nora was talking about it, is waiver. So they would get the clients to waive their rights. How? They would say, you know, it's redundant. You can talk to your defense attorney, but that means you'll have to wait, and probably you'll have to wait in prison or in jail, and better talk to us, we could help you. Or they would just inform the right by mumbling and moving on to something else and starting the actual interrogation. Another thing that another manipulation is that when the right applies only when there is a formal arrest. So sometimes they would say, well, this person is not arrested yet. They would question, and then they will arrest later. So these are two of the main. So low compliance by the police, partial services by the public defender. We used to have an on-duty attorney on call from 7 a.m. till midnight. So this was partial. During the nighttime, we did not have an arrangement. And another manipulation that we saw is that at 12:15 or so, we would get many calls or messages by fax from the police. We have a person wanting to exercise their rights. So they knew our offices are closed after midnight, and then that's another way to manipulate. And the fourth one was lack of public awareness. So many people, those who are not, especially the marginalized, the people who are not educated about their rights, they would just don't know that they have the right and how important is the right to counsel. So these were the major challenges. And then I'll move to the actions that we've taken. And I'll say a few words about each. Case-to-case litigation, public defense around the clock, meaning 24/7, and collecting and disseminating data. These were the three main prongs of our action. So, case-to-case litigation. That was mentioned before in Holly's presentation that I liked very much. And here's what we got through case-to-case litigation. We instructed our attorneys to argue, for example, for the right to get a warning, okay? So now we went up to the Supreme Court, and so now there are clear rules about when and what should a police officer say to a person who's arrested. So now they have to say that they have a right to counsel, and that counsel should be afforded. If someone cannot afford counsel, they have a right to a public defender, and the timing of that warning is before any questioning. So now there is clear rule about that. Another important clear rule that we achieved through litigation is exclusion of evidence. So in trial now, we can suppress or exclude evidence that is obtained following a violation of the right to counsel. This is very important because it goes through the incentive of the police to violate the right, and now they're more careful about it. And a development of this was, and this was also mentioned in Holly's presentation, is that we convinced the courts that it doesn't have only the effect on the trial, exclusion of evidence, it can have the effect on the arrest. So if someone's right to counsel is violated, we can argue on the arrest stage that the remedy should be release. It's not always like that, but it is one of the considerations. And I think this was in a way a game changer, because the police really cares about the immediate stage. Sometimes they don't see far enough to say, okay, this may endanger our case when it goes to trial. But if they see that they violate the right and the morning after there's an effect to that in the sense of release, this has an immediate influence. Okay. So this was a case-to-case. The fourth one would be the other thing that we achieved through litigation is the issue of waiver, but I will save this to the end. Okay, the next thing we did is to change the situation where our services were limited only up to midnight. It was a whole, apparatus that we have to build of on-duty counsel throughout the night. I have to say that, so now it's 24/7. I have to say that in the beginning, we started it as a pilot. I was suspicious. I didn't know if it would work. Attorneys have to get calls at 2 a.m. in the morning in the winter and drive to sometimes a remote police station. It's not that easy. So when we started the pilot in Jerusalem, after 1 month, I met with all the attorneys who volunteered to do that job, and I was afraid. I thought I was going to get so many complaints, and I was so surprised. It was the vice versa. They were actually finally feeling that they were doing something meaningful. So they would say, I went to this police station, I saw sometimes a juvenile, for example, and because of my presence there, that boy was released. And I saved that boy the trauma of being in a detention house for the night. So I found that despite my hesitations, actually they were really feeling great about it. They say, why don't we, end the pilot stage and we do it all over the country, and this is what we did. So today we have 24/7 scheme for on-duty counsel. And the last one, which was also crucial, was collecting and disseminating data. You cannot understand that, but I'll tell you. What we did is that we changed our computer system and we document for every client whether they got early access to counsel and what is the district and the specific police station. And today, by pressing a button, I can say that in one police station, the compliance rate is 90%. You see the upper one, you don't see, believe me, the upper one is 96%. So they comply, they get, in this police station, almost everyone gets the right to counsel, early access right to counsel. And in the next one, it's only 39%. So what is the difference? So this allows us to tell the police, it can't be just waiver. Right? It's not that in one police station everybody waives their rights because they are, people that tend to waive their rights. And in other questions, they're all stubborn and they want to. So it has to be dependent on the police practices. Sometimes we see that even one police officer that moves from one station to another can change the picture. So it's about how they explain the right and whether they're really informing correctly the person of the right. So we use this information and we meet with the chief police officers, both on the district levels and up to the general director of the police in Israel. We send them this information. What we find is that the higher command, they want the change. So they understand that it is important. The problem is with the ground, and when we are able to show them this data, they can press on the areas that are more problematic and improve those specific areas. Okay, so I'll end with the remaining challenges. So here are the remaining challenges. I will start with the second one. Second one is a law, a proposal, a bill that we are promoting. If it passes, every suspect, even one that is not under custody or arrest, if they're indigent, will have the right to a public defender. Obviously, it has budgetary implications. I'm optimistic and I think it will pass in the end. And then the first one is the waiver that I mentioned. So I'm happy to report that just in August we won a Supreme Court case in which the court said that the police is obligated to inquire whether the suspect has indeed waived his right to counsel. Also, the waiver should be documented by video audio recording to allow judicial review regarding the suspect's exercise of the right to counsel. So this is great. It's relatively new, so now we're arguing this in courts, but it's very, very, very important, and especially the fact that they're saying video audio documentation as opposed to just a paper, so you can get someone to sign a paper, especially if they're arrested, and they're not understanding what they're signing. That could happen, and I saw that happening in many places. So now if they obey this rule, and we're going to force them to obey this rule, it has to be documented, videotaped, and I think this is another, or has the potential to be another game changer. And the last one is disseminate information. I was talking about the public not being aware of their rights. So we're now in the phase of, letting the public know what are their rights and why are they so important. Here you see in Hebrew and in Arabic, 5 things you need to know. Okay, so one of them is the right to counsel and other important issues. We disseminate that through Facebook and other means. We also have a video clip regarding juvenile rights, and we're working on more ways to disseminate this information to the public. So today, I said almost half in 2017, but today it's 54% actually in 2018. Is the glass half full or half empty? So it's a great progress from 10% to 54%. I guess it depends on your view, whether you're optimistic or pessimistic. As a defense attorney, I must be optimistic. And I see that the glass is definitely getting fuller. 54% is much better than what we had, but we still have another half of the glass to fill. Thank you very much.
Thank you. Thank you for this really interesting presentation and really interesting figures and success stories you shared with us. Let's move to the next speaker. We'll move now to Ukraine. Mr. Konstantin Bushuev, who is a Deputy Chief of the National Police.
Добрый день. Спасибо организаторам за то, что дали возможность представить полицию Украины. Я думаю, не только Украины. Пользуясь случаем, попрошу оставаться всех на местах. Шутка. Да, действительно, вот и господин Йов, и другие спикеры, и в целом на протяжении вчерашнего и сегодняшнего дня мы говорим много о праве на первую юридическую помощь. И Украина находится в таком уникальном положении, когда последних 3 года мы проходим процесс трансформации, реформ всей правоохранительной системы, и национальная полиция есть таким себе пионером в продвижении большинства современных решений, в том числе с учетом опыта, который мы, собственно, приобретаем и во время общения с нашими иностранными коллегами, визитами, изучением тех практик, которые имеют положительный результат в вопросе обеспечения, в том числе, прав задержанных. Но в свою очередь мы не отбрасываем на второй план также и технический прогресс. Сегодня я попытаюсь вам представить проект системы, которая называется Custody Records. Буду честен, ее основу мы посмотрели в Великобритании, но существенно доработали, учли все проблемы, в том числе и британской стороны, максимально интегрировали ее в правовое поле Украины и попытались соединить с другими механизмами, которые существуют в том числе и в других ведомствах. В данном случае речь идет о Минюсте, и направлены на обеспечение прав человека. Собственно, к делу. Еще раз о том, что нас подвигло к разработке этой системы. Но прежде всего это высокие риски нарушения прав человека на протяжении первых часов задержания. Это размытая совместная ответственность сотрудников полиции при условии отсутствия институционального закрепления ответственных за соблюдение прав задержанных в полицейских участках. Ну и, конечно же, отсутствие удобных процедур контроля за пребыванием задержанного в условиях ограничения то ли в detention центре, то ли непосредственно в полицейском участке. Какие цели и задачи мы перед собой поставили, когда планировали реализацию этого проекта? Безусловно, это обязательное интервью, предоставление в изоляторе временного содержания, так званый detention центр. Электронная фиксация всех действий, касающихся задержанного лица. Причем речь идет о всем процессе пребывания этого человека в условиях ограничений. Посредством современных технических решений мы обеспечиваем внешний мониторинг процесса содержания посредством осуществления простого визуального контроля за системами и базами данных, которые реализуются посредством функционирования системы Custody Records. Ну и немаловажный аспект и вопрос – это, конечно же, защита в том числе правомерных действий полицейских и в целом полицейских от, условно говоря, неправдивых сведений касательно ихнего превышения полномочий. Какие ожидания у нас сформировались во время разработки и реализации этого проекта? Прежде всего, это усовершенствование стандартов защиты прав человека. Тут господин Йов буквально перед этим говорил о том, что в разных отделах полиции есть разная статистика, скажем так, предоставления права на защиту, где-то 96%, где-то 30%. Так вот, именно формируя такую систему, мы стремимся к тому, чтобы единость подходов, устойчивость алгоритмов действий приводила к тому, что количество обращений за предоставлением первичной помощи были на одном уровне вне зависимости от человеческого фактора или желания-нежелания того или иного должностного лица, уполномоченного на осуществление деятельности, связанной с предоставлением этой помощи. Безусловно, также мы ставим перед собой цель сокращения всякого рода бюрократических процедур, связанных с ведением разного рода журналов, записей и других ненужных, как по мне, учетов, которые довольно-таки эффективно заменяют электронные системы. Ну и, конечно же, это объединение усилий всех служб, которые работают и с задержанными, с целью упрощения процесса не только ведения документации, а контроля за ее полнотой. Система настолько же проста, настолько же и сложна. Но основные ее составляющие – это институт специально подготовленных инспекторов, который занимается только задержанием. На сегодня в уголовно-процессуальном законодательстве Украины есть норма, которая предусматривает наличие уполномоченного сотрудника в органе досудебного расследования, ответственного за содержание задержанных. Но проблема состоит в том, что тут возникает некий конфликт интересов в силу того, что этот человек находится в структуре подразделения, которое применяет ограничения. И, к сожалению, в компетенцию этого человека не относится проблематика, связанная с содержанием людей в административном порядке. Исходя из этого, мы говорим о создании институции, которая позволит на уровне конкретного подразделения полиции определить конкретное должностное лицо, которое будет заниматься от момента задержания до момента оставления этим лицом соответствующего подразделения соблюдением всех тех процедур и алгоритмов, о которых я говорил выше. Вторая задача – это, безусловно, внутренняя регуляция. Это всеобъемлющее понятие, которое позволяет нам говорить как о развитии сети, так и наполнение этой сети соответствующими информационными массивами, включение сюда также функциональных моментов. Ну и эта составляющая очень здорово соединяется с электронной базой. Почему? Потому что как раз в структуре внутренней регуляции электронной базы должны функционировать, помимо прочего, то, о чем говорил господин Йов, системы видео и аудиоконтроля процессов, связанных с проведением первого опроса или же фиксации момента отказа или требования задержанного оказания ему первой юридической помощи. Ну и, как я говорил ранее, это внешний мониторинг, приведение системы, которая включит в себя абсолютно весь спектр информации, связанный с момента задержания и момента пребывания человека в органе полиции, имеет возможность и доступ к этой системе. Подразделение, которое создано в национальной полиции, называется Управление обеспечения прав человека. Это люди, которые непосредственно занимаются проблематикой содержания, соблюдения законодательства и контроля за соблюдением этого законодательства во всех 125 detention центров, которые находятся в Украине, а также 680 отделов полиции, которые существуют на территории страны. На этом слайде я хотел бы представить вам учетную карточку, условно говоря, или профиль задержанного, которая должна оформляться в первый же момент после задержания с сотрудниками полиции того или иного человека. Собственно, в этой карточке, может, не совсем хорошо видно, но обозначены все те вопросы, которые обычно, как показывает анализ или практика, полицейские не совсем готовы задавать. В том числе это вопрос касается того, применялось ли насилие в отношении человека во время задержания, требуется ли ему медицинская помощь, вопрос фактического задержания. Ведь не секрет, когда мы говорим о юридической плоскости, то факт юридического задержания очень часто разбегаются с фактом фактического задержания. И как раз проводя первое интервью в полицейском участке, в рамках которого заполняется соответствующий профиль, мы имеем возможность также контролировать вопрос юридически правильного процессуального составления документов, связанных с задержанием. На данном слайде я попытаюсь вам представить новый формат работы изолятора временного содержания. Впрочем, насколько он отличается от предыдущего, очевиднее всего, в первую очередь тем, что максимально в работу этой организации интегрированы системы видеонаблюдения, звукового наблюдения, а также современные компьютерные системы, которые позволяют вести и дополнять те учеты, которые формируются посредством заполнения предыдущего профиля. Следует сказать, что вот на данном примере четко изображена структура небольшого изолятора временного содержания для людей, которые, собственно, ведут постоянный контроль, выведены соответствующие мониторы, что позволяет им отслеживать ситуацию непосредственно во всех блоках и помещениях этой организации и вести соответствующие дополнения. Когда мы говорим о системе Custody Records, то в электронную систему мы помещаем не только факт пребывания человека там, а абсолютно все действия, которые связаны с этим человеком, вплоть до оказания помощи, приема пищи, передвижение в санитарную комнату или какие-либо другие мероприятия, что, собственно говоря, в дальнейшем должно синхронизироваться с видеорядом и аудиорядом, которые позволят нам максимально точно понимать, в каких условиях находился этот человек, не поддавался ли он физическим или психологическим воздействиям с целью применения или получения конкретного результата органами досудебного расследования. Данный слайд демонстрирует, скажем так, ту идеальную структуру, к которой мы на сегодня стремимся. И тут впору говорить как раз о том, что современные технические решения, которые широко используются в практических подразделениях национальной полиции, могут послужить хорошим, скажем так, подспорьем тому, чтобы устранить максимально влияние человеческого фактора или какой-то субъективной точки зрения или отношений к конкретному задержанному лицу. О чем идет речь? В процессе задержания мы планируем реализовывать посредством планшетного компьютера формирование первой карточки учетной о факте задержания, фактическом задержании. То бишь, если на пальцах, это будет примерно выглядеть так. Патрульный полицейский, который задерживает, по его мнению, правонарушителя, делает в электронной форме в планшетном компьютере, которым оборудованы на сегодня все служебные автомобили патрульной полиции в Украине, отметку о задержании. Соответственно, этот электронный протокол имеет два направления движения, одно из которых информирование центров правовой помощи, которые функционируют при Министерстве юстиции, что в свою очередь снимает проблематику, о которой говорил буквально перед этим господин Йов, и фактически информирование данных центров уже не зависит от воли того или иного сотрудника полиции, а соответствующий центр в автоматическом режиме получает информацию и принимает решение о направлении уполномоченного лица, то бишь адвоката, в конкретный отдел полиции для разбора по конкретному вопросу. По прибытию в отдел полиции формируется бумажный протокол, и, соответственно, это становится основой и прообразом формирования учетной записи в системе Custody Records. В дальнейшем, после принятия решения уполномоченным лицом, мы понимаем два возможных направления, но как бы там ни было, в этих процессах однозначно присутствует представитель защиты, адвокат. В общем-то, система довольно-таки емкая. Я попытался очень коротко объяснить суть, смысл и порядок ее функционирования, но в дополнение к этой системе мы совместно с правозащитными организациями, которые играют не последнюю роль в осуществлении этого проекта, работаем также над таким себе прообразом права Миранды, разрабатываем памятки, которые несколько отличаются от тех, о которых господин Йов говорил только что. Они касаются всей категории процессуальных лиц, в том числе и пострадавшего, свидетеля и задержанного. И на сегодня мы провели соответствующую апробацию этого эксперимента в одном из регионов Украины, довольно-таки большом регионе, в рамках которого обеспечили распространение этих памяток на 12 языках. На 12 языках, которые наиболее распространены в этой локации. И результаты, которые мы получили, утверждают нас в том, что мы двигаемся в правильном направлении. Собственно, я думаю, это будет хорошим дополнением к реализации системы Custody Records. Вот. Ну и будет в конечном итоге иметь положительные отзывы, в том числе от тех, кто требует защиты. У меня все. Готов буду ответить на ваши вопросы. Спасибо за внимание.
Thank you. Thank you for a really interesting presentation. We need to move quickly to the next speaker since we are running a bit out of time. Mr. Michael Mrozinski, staff attorney at National Legal Aid and Defender Association from USA.
Gamardova. Hello, my name is Michael Mrozinski. I'm a staff attorney with the National Legal Aid and Defender Association. We're a non-governmental organization in the United States that supports civil legal aid, civil and criminal legal aid providers around the country and promotes standards for more equitable justice systems. Through the support of the MacArthur Foundation, I've been doing research and producing a paper on access to counsel at a defendant's first appearance before a judicial officer. That's sometimes called an arraignment or a bail hearing. And I'd like to summarize some of that research for you and give you some of the American perspective on how counsel at first appearance has worked in various jurisdictions around America. So just as a kind of primer on some of the basics of the American criminal justice system, we do have a de jure presumption of innocence. Technically speaking, you are innocent until proven guilty. In practice, that's not always the case. In the U.S., there are about 465,000 people who are currently in jail who have not been convicted of a crime. They're, like I said, presumed innocent, but they're still in custody. That accounts for 2/3 of all people who are in jails around the U.S. And for about 20 to 25% of all people who are incarcerated around the country. In the United States, you also have a constitutional right to counsel in all criminal prosecutions. The Supreme Court has stated in 1963 that includes a right to legal aid if you cannot afford an attorney. More recently, with relation to counsel at first appearance, they've said that you have a right to an attorney at all critical stages of the proceedings. And that's really all the guidance they've given. They haven't given a distinct yes or no. Some states like Massachusetts and New York have, the highest courts of those states have said that you have a right to counsel at first appearance because it is a critical stage since liberty interests of the accused are at stake. And as Alex from the ACLU mentioned earlier, the U.S. has a lot of different jurisdictions, 50 states plus territories plus sub-state level courts. So that means there are a lot of systems, a lot of courts, but it also makes kind of a natural laboratory for experimenting on different ways of approaching criminal justice. Now, research on counsel at first appearance, or CAFA, as I've abbreviated it here, has shown, on the whole, benefits to clients and to systems. First, on clients, we see better client outcomes if they have an attorney at their first appearance proceeding. That means less time that they spend in jail. Their attorney is able to get them a better outcome at that hearing. Higher rates of release on the day of that proceeding and high rates of release on the day of arrest if it's the same day as that proceeding. We see lower bail amounts in cases where the defendant has an attorney at that first appearance proceeding, and importantly, higher client satisfaction with the proceedings. They feel they've gotten a better proceeding, a fairer proceeding, and that sense of procedural justice is maintained better when you do have counsel at that proceeding. We also have systemic benefits. So you have lower rates of recidivism when you have counsel at first appearance. We know that even 72 hours in custody, in jail for someone who's been accused of a crime can have destabilizing effects on their lives. They can lose their job. They can lose their income stream. That may mean that they're not able to afford housing. They may lose their rent money if they have to pay bail. It's a lot of destabilizing elements, and having the counsel at first appearance to keep them out of jail reduces those kinds of pressures that may push them toward crime in the future. You also have lower jail populations, and that's really one of the main purposes of the MacArthur Foundation Safety and Justice Challenges work behind this is they're looking to reduce jail populations, and counsel at first appearance is effective in doing that. It's also more cost effective. You spend less money on criminal justice if you're not locking people up. In the US, we spend about $13.6 billion, billion with a B, every year on pretrial detention alone. The cost of incarcerating one person for one night in jail can range anywhere from about $46 US to over $500 US per person per night. So those costs of keeping someone in jail pretrial really do add up. Additionally, it's more efficient to have counsel first appearance. You end up with fewer hearings, and on the whole, the criminal justice system can move a little bit faster and, importantly, more equitably. So like I mentioned, the lowering jail populations is really one of the main drivers behind the push for counsel first appearance in the United States. Jail populations have exploded over the past 30 to 40 years, and as you can see on this chart here, that light blue bar with the bolded numbers, those are people who are presumed innocent and who are still in jail. And the increase in jailing those people has really driven the increase in jail populations over the past few decades. Now, like I mentioned, there's been some different research that's been performed on counsel at first appearance in various jurisdictions around the United States. 1999, Professor Douglas Colbert conducted a study in Baltimore, Maryland, where he found that if you have a counsel at that first appearance proceeding, you're approximately 2.5 times more likely to be released on your own recognizance without paying bail at that first appearance proceeding. You're about 4 times more likely to have your bail amount reduced. You're about 2 times more likely to be released on the day of arrest. Additionally, we found, I don't know if I have time to run through all of these different client satisfaction outcomes, but broadly speaking, client satisfaction is greatly improved, as shown by this Baltimore study. You feel like you got a better outcome than you would have otherwise. You got a better outcome than people who don't have attorneys, and you feel like you, the judge, that the other people in the courtroom heard your side of the story, which is a really integral piece of procedural justice. There have been also some recent studies in upstate New York that have shown, and again, this is a little bit complex for the time that we have, but the gist of this is that we have an increased percentage of defendants who are freed after the initial appearance proceeding. This study was done in a few counties in upstate New York, so 21% increase in release rates in Lake County, and a 15% increase in Hudson County, more people getting out on the day of that first appearance proceeding. Additionally, and I don't have graphics for these, but there are also some other notable examples around the United States of different counsel at first appearance studies and pilot projects. In the state of Michigan, there was a 3-county pilot project done, and in those various counties, they found 28% less time spent in jail between arraignment and release, 11% fewer hearings in one county, and bail was set at the amount recommended by the attorney in 30% of cases, and at a lower amount in 59% of cases. Additionally, and this is some very new emerging research coming out of Alameda County, California, that my organization, NLADA, has been helping to push forward. A pilot project out there in the city of Oakland has found that the public defenders there who had not provided counsel at first appearance before, under this pilot project, they are providing counsel at first appearance. The release rate at that first appearance proceeding has increased from about 0.75%, under 1%, to a little over 20%, which is a really staggering increase and shows the power of just having someone there to advocate at that first appearance proceeding. Quickly, I want to run through some of the challenges and successes and solutions that different jurisdictions have faced in implementing counsel at first appearance programs. One of the problems is just getting buy-in from other stakeholders, from the decision makers, the people who are funding these kinds of projects. And some of the solutions are to expose them to some of these studies about counsel at first appearance. My paper is coming out early next year, but there are a bunch of other studies out there that show the effectiveness of having an attorney at the first appearance proceeding. And yeah, share examples of successful implementations of these different pilot projects and show that it's not just a theoretical benefit, that these systems really do work. There are also concerns about the cost of providing counsel at these proceedings. There are a couple of different answers for that. For one, yes, there is going to be some upfront investment needed to improve justice systems, but on the back end of that, with lower costs in jails and staffing those jails, you can see considerable savings in your criminal justice costs. Having enough attorneys to cover the first appearance proceedings can also be an issue, which can lead to longer waiting times for clients. There are the solutions to this kind of problem are going to vary from jurisdiction to jurisdiction, and it's going to vary based on what kind of system you have for staffing your legal aid office. So it's going to require a little bit of creativity. You might expand the roster of attorneys that cover the first appearance proceedings, or even involve private attorneys on a contract basis or an assigned counsel basis to help cover those proceedings. And last, we've found in some jurisdictions it's difficult to provide vertical representation, that is, having the same attorney represent the client at the pretrial proceeding as well as through the trial. One jurisdiction that faced this problem, I should say, decided to split up the representation, have attorneys that just cover the pretrial and attorneys that cover the trial. That's not optimal, and I should say that there are really no perfect systems out there. This is just a solution that they've found to encounter that particular problem and overcome it. I'm going to close on a couple of key points of implementation of counsel at first appearance programs. For one, attorneys need to have access to their clients, and that's especially true when they're in jail, in custody. Access to the client to learn about the case, to be able to provide that zealous representation and effective representation at the first appearance is really critical. Sorry, I skipped over my first point. There are going to be some initial stumbling blocks, some growing pains when you're implementing a new program like this. It's going to require some adaptation and some problem solving at the top. You just need to be prepared to overcome some of those issues. And really quickly, just time to prepare the case, equity and discovery. If the prosecutor has evidence in the U.S., the public defense is also required to get that same evidence. And privacy and communications between the attorney and client. In the U.S., there's been an issue with the use of video conferencing and video conferencing a defendant from the jailhouse into the first appearance proceeding and not really allowing for any kind of confidential communications between the attorney and client. That's probably not going to be an issue everywhere, of course, but that's just one of the issues that's come up in the U.S. So thank you very much for having me. Thank you for your time. If you have any questions, please feel free to email me. Thank you.
Thank you, Michael, for interesting figures and interesting presentation. We now move to our final panelist, Nicole Taylor from International Legal Foundation. Now we'll have a more comparative approach rather than individual state.
Good afternoon. Can everybody hear me? Okay. All right, great. So thank you for the opportunity to speak to you today about strategies for introducing early access mechanisms in post-conflict and transitioning countries. Okay, good. So early access to counsel is fundamental to rights protections. And early access mechanisms should be built into every criminal justice system. It is the best way to protect against abuse, torture, illegal detention, false confessions that often occur during the earliest stages of the case. Despite the global crisis in legal aid, created in part by a failure of jurisdictions around the world to ensure early access to counsel for all accused, particularly those most vulnerable, including poor and otherwise marginalized populations, we consistently find references in law evidencing the government's responsibility to provide early access to counsel. Here are 3 examples from Tunisia, Nepal, and Palestine, and Nepal's is particularly clear. Any person who is arrested shall have the right to consult a legal practitioner of his or her choice from the time of such arrest and to be defended by such legal practitioner. Governments in every part of the world struggle to implement the right to counsel. For countries in transition, the challenge is even greater, as there's often a lack of resources, capacity, and political will in building sustainable early access mechanisms. At the International Legal Foundation, we work in countries in transition: Afghanistan, Tunisia, Nepal, Palestine, Myanmar, where governments are engaged and are committed to legal aid reform, and where there still exists major gaps in rights implementation, particularly on ensuring early access to counsel. As a result, we have developed strategies for working with governments to ensure that they are able to protect this right. Can we see that? Okay. So first, early access strategies must be rights-based. This requires a thorough analysis of local laws and procedures, as well as international guidelines, laws and guidelines, such as the Universal Declaration on Human Rights, International Covenant on Civil and Political Rights, and the UN Principles and Guidelines on Access to Legal Aid and Criminal Justice Systems, all of which support the development of rights and mechanisms for the provision of early access to counsel. In analyzing the law, it is important to identify where the right to counsel attaches, as well as the procedures that create opportunities for access and the development of early access mechanisms, such as counsel at first appearance and police station duty lawyer programs. 2, build a defense culture. Civil society organizations that provide legal aid can play a critical role in pushing for access to counsel as close in time to arrest as possible, particularly where transitioning governments lack the capacity and resources to do so. Legal aid providers who should develop case intake mechanisms and case intake policies that require lawyers to provide representation at the earliest possible stages. This is actually the first principle of ILF's 10 practice principles articulated in our 2016 Measuring Justice publication, defining and evaluating quality legal aid for legal aid providers, and I kind of put it up here for you to read. Legal aid providers should work in a practical, everyday way, right, to build relationships with judges, police, prosecutors, in districts and cities and municipalities that serve to support the development of early access mechanisms. Legal aid providers must also challenge the failure to ensure early access to counsel through pretrial and strategic litigation, educating courts and prosecutors and police about the law and pushing for changes to procedures that open the door for sustainable early access mechanisms. To help answer questions about the need and the impact of early access to counsel, legal aid providers should develop systems, however basic, for gathering data on the stage of access as it relates to a number of different variables, including but not limited to case outcomes, the length of detention, investigation, pretrial motions, client satisfaction, client communication, recidivism, etc. Justice sector coordination. So all of this implementation that I discussed does not happen in a vacuum. In order for implementation of laws protecting early access to counsel to be sustainable, it must be organized, structured, and consistently implemented. This is achieved through meaningful justice sector coordination. Any early access mechanism must involve committed coordination between police, prosecutors, judges, the private defense bar, legal aid providers, ministries, and administrative legal aid committees and boards. Actively engaging tools such as trainings, workshops, roundtables, working groups allow the sector to grow together in its understanding of the importance of early access to counsel, the roles and responsibilities of various actors, the challenges and solutions for getting it done. These tools provide opportunities for everyone to be heard, and they build the buy-in needed to develop sustainable cross-sectional agreements for the provision of early access. Rights awareness, number 4. A necessary complement to the implementation and the justice sector coordination discussed above is increasing the awareness and understanding of citizens about their rights. The goal is to use simple, clear, and instructive language to help people to understand their rights upon arrest and how to advocate for them. More importantly, or most importantly, for poor and marginalized people, suspected, detained, or arrested for a crime, is building the understanding about the availability of legal aid and how to request it. We did this rights awareness poster in Palestine, which explains what people should do upon arrest, provides information for legal aid providers, including our ILF West Bank office and the Palestinian Bar Association. And we posted it in schools and community centers, etc. Rights awareness campaigns on campuses and schools and community centers normalize the concept of early access to counsel. A more informed citizenry can place pressure on governments to develop meaningful and effective early access mechanisms. 5, pilot early access initiatives and scale up. Post-conflict and transitioning governments that are working to build fair justice systems, for them, the idea of developing a mechanism that ensures early access to counsel for every arrested person can be daunting, right? It can be daunting for them. But pilot programs are a useful way to help governments start on this journey. An example, in Nepal's Lalitpur District Court, a small district adjacent to Kathmandu, ILF Nepal, in partnership with Public Defender Society Nepal, and in coordination with the court, prosecution, the Nepal Bar Association, and the police, are working together to implement the law granting early access to counsel. Starting in this one district, the team will pilot a counsel at first appearance mechanism, where every person who appears before the court at first appearance has access to a lawyer. The group will monitor the success and challenges faced, gather data on impact, and work as a collective with Nepal's government to determine how to scale up. The result may look similar to ILF Afghanistan's duty lawyer program. That program grew from a pilot in one province, in Helmand, and is now in 13 provinces throughout Afghanistan. And finally, 6, build early access provisions into legal aid policies. More than ever, governments in transition are committing themselves to developing legal aid laws. In doing so, they should build early access provisions into legal aid policies and regulations using available local and global expertise and the practical experiences of legal aid providers and other justice sector actors who are doing this work in their countries every day. A prime example is Myanmar's new legal aid law, which establishes that legal aid providers, and I have it up here for you to read, legal aid providers can provide defense to people during the first court hearing and while they are in remand custody. Government should also take into account the best practices, right? Such as ensuring that eligibility determinations do not stand as a barrier to access to counsel. Also, engaging in monitoring and evaluation to ensure that early access to counsel is provided in a meaningful way in accordance with performance standards and guidelines that support diversion, detention alternatives, and comprehensive representation. Creating rights-based mechanisms that connect people to lawyers as close in time to arrest as possible, and ensuring equal access, which is clearly important, universally to vulnerable populations, including poor people, children, women, people with mental health issues, and other disabilities, and without discrimination, meaning a person's religion, gender, race, ethnicity, finances, nature of the case, social status, sexual orientation should never, ever act as a barrier to access to counsel. And my final point is that these strategies intersect, right? And so they should be employed together. And the resources and capacity of a government may impact a government's ability to implement any or all of these strategies. But the most important strategy is to start, to move, take that first step towards really trying to create better rights protections. And as we have heard, early access to counsel is the best way to do so. Thank you for your time. Look forward to discussion.
Thank you. Thank you for an interesting presentation. We are really getting close to lunch, which is really crucial, especially in Georgia. But we usually can find some, like, let's say, 5 more minutes, and we can take a few questions, and then we can make answers to it. So I see 1, 2. Okay.
تحياتي لكم. أرجو أن أتكلم باللغة العربية. أرجو أن يساعدني صديقي مأمون في الترجمة. ابتداء لا بد لي من تقديم الشكر من الوفد الأردني لدولة جورجيا الرائعة والجميلة، وأيضا للمنظمين لهذا المؤتمر المميز. المحامي يوآف سابير ممثل الاحتلال الإسرائيلي للأراضي العربية الفلسطينية.
Unfortunately, the translation is not working, I think. Apologies for interrupting.
أنتم تحتلون أراضي الفلسطينيين وتمارسون كل وسائل التعذيب والتنكيل والاعتقال والأسر والدمار لهذا الشعب الأعزل من السلاح. هناك أعداد إحصائية لعدد الأسرى في سجون الاحتلال، حيث يوجد 7000 أسير وأسيرة، منهم 6000 أسير إداري لم يعرضوا على المحاكم وتم توقيفهم بشكل غير قانوني، وهناك 58 أسيرة، وهناك 320 طفل دون سن 18، منهم 47 موقوفون دون محاكمة. من الأسرى هناك 13 نائبا من أعضاء المجلس التشريعي. فأنا سؤالي هو أين دوركم كمحامون في الدفاع عن هذه الحريات، وأنتم الذين حلفتم اليمين على إحقاق الحق بمواجهة ذلك؟ ولا نقول في الآخر إلا الحرية للأسرى والمجد والخلود لشهداء فلسطين، وفلسطين عربية والقدس عاصمتها الأبدية. وشكرا. سقفوا يا جماعة.
I think there was an issue with the translation. Will we have some volunteer who will make, like in English, small translation of the question? I apologize for this, but unfortunately it was not working all the time.
Okay, I can maybe summarize.
Please.
The question is more to the Yoav, Mr. Yoav. It's about, he's asking that Yoav is representing the Israeli occupation, and he is asking also, how is your commission or the public defender in Israel is, you are providing legal aid, legal presentations to thousands of Palestinians war prisoners in the Israeli jails, and you have the oath to, you already did the oath to provide support and help people to get justice, and we need to understand if you are providing this kind of service also to Palestinian war prisoners.
Sorry, I need, there is some missing points in the translation. First of all, the gentleman from Jordan, he sent a very warm salutation to the Georgia people for the warm welcome they provided for them. On the other hand, he was addressing the question, as he said, the new translator, but also he added certain data, and those data, I believe, are very important for the person who will answer, because he was referring to numbers of people who were arrested without trial in the jails of the prison of your speaker, and I believe it is important that the gentleman from Jordan will tell us about those data so we can translate it so that he can understand very well what we are talking about. أنا بطلب من الزميل من الأردن يرجع يقول الداتا الأرقام اللي قالها من أجل أن تكون على مسمع المتكلمين.
نعم أشكركم. عدد الأسرى في سجون الاحتلال الإسرائيلي للفلسطينيين 7,000 أسير وأسيرة.
The detainees in the jails of Israel are 7,000 without trial.
منهم 6,000 أسير إداري.
Among them 6,000 detainees under administrative rules.
لم يعرضوا على المحاكم.
They didn't have the right to a fair trial.
وهذا توقيف غير قانوني.
And this is illegal.
And 58 أسيرة.
And 58 women who are under arrest.
و320 طفل دون سن 18.
And 320 juvenile under 18 years old.
منهم 47 موقوف دون محاكمة.
Among them 47 who are without trial and are under arrest.
وهناك من الأسرى 13 نائب من أعضاء المجلس التشريعي.
And among them who are arrested 13 elected representative of the National Assembly.
وشكرا.
شكرا. Thank you.
Okay, let's take a few more questions, please.
Здравствуйте, меня зовут Виолетта Удадю. Я из Молдовы. Я параюрист или исполнительный директор Национальной ассоциации параюристов из Молдовы. У меня есть вопрос к господин Сапир. Господин Сапир, вы сказали, что служба адвокатов у вас есть 24 часа. В Молдове то же самое есть. Я хочу спрашивать, адвокатов в этих часах находятся всегда в полицейские участки, или они находятся дома или в других местах, и у них есть такой договор с полицейским, чтобы они сообщали им по телефону или как-нибудь по-другому, что для них есть клиент в полицейские участки, так как бывает в Молдове. Спасибо вам.
Thank you. Yeah, Konha, then two more.
Yes, I have one question concerning the Austrian experience. I think it was mentioned that the defendants can call from police stations. There is a hotline from police custody. They can talk with the lawyer on the phone. We are also thinking about this experience, implementing this in Georgia. But there are several questions, and one of the questions is how do you preserve the confidentiality? And where is, physically, how is this possible? How do you make it possible physically? Do you have a separate room? Do you have a separate space for the phone conversation with the lawyer? Thank you.
Thank you.
Yes, my question is to Yoav. I was hearing to your intervention quite interested about the 24/7 service implemented in Israel. So my question goes regarding how does the public defender knows that the person is in custody? Do you have any, because in Argentina we are trying to implement it, but the problem is to get the police to tell us. There is no police interrogation in Argentina, so the person will always talk, before talking to the judge or the prosecutor, he would have the public defender, but we are not told by the police because the law doesn't say that. And on the other hand, on the same issue, you told us an example of a public defender when you had this meeting and you were like quite surprised and he was happy because he avoided some person to spend the whole night in the police station. So how was that? Because, for example, in our case, the police has not the right to free a person, to release a person. So how did that happen? I mean, we always have to wait the person to go into the into the court or the prosecutor's office once he got into the police station. So how would that happen? Thank you.
Zazan Moderator. My question is to Mr. Konstantin Bushuev. I'm really delighted he's with us and made this presentation. The suspect's rights during police custody and during early stage of the proceedings is obviously, we all know, is crucial. But it is the area where police engagement is also crucial. There is kind of that much what lawyers can do. So without police really protecting and facilitating defendants' rights to be realized, it is very hard to make them work in real practice. So I was really pleased that he's with us, and I think in the future probably we'll need more engagement and more speakers to come from police institutions to our events when we discuss early access and suspects' rights. So my question now is, could you, what you presented is absolutely impressive. Would be great to understand what are the challenges you're experiencing to roll out your vision. This is very significant reform, and so maybe there are opposing parties to that or other obstacles that you experience. And the second, are you already having some data, or are you observing improvements of suspects' rights as a result of your innovations? If there's some findings already in this regard. Thank you.
Thank you. We have just 5 minutes maximum for all the answers. I know there are many questions, especially to you, but let's try to be really short and succinct. Thank you.
And that's fine. I'll try to keep it short, but I'm happy to have more discussion during the break. As I said yesterday, 20%, a big minority of our clients are non-citizens, actually 20% of them, and a vast majority of these 20% are Palestinians, so our office represents Palestinians as well as Israeli citizens for cases that are within the boundaries of Israel. If someone is accused in Israel, they get the same representation, the same standard applies, early access that we just discussed, everything applies the same. It is true that there are military courts within the territories. Our office does not deal with it does not have the authority to represent clients in the military courts. In the military courts, there is a court-appointed system that is different. Usually, there are both Palestinian attorneys there and Israeli private attorneys who represent there. As for your question, so one is how do we know that someone's arrested? So if after the police informs the suspect of his or her rights and they choose to exercise those rights, then the police is obliged to call us and say this and that person is suspect of whatever the suspicion is, and then we send our on-duty counsel. So they do have the obligation. Sometimes they avoid it, as I explained, and we try to fight that through courts. As I explained, if we only hear about that person in the court hearing, then we know that something happened, and then we have to go back and look, why didn't they call us? They would probably argue that it's a waiver, and then we'll challenge the waiver, and so on and so forth. And the second question was, how come the police releases an arrested person? They definitely have the authority to do that. They can release a person and give them also condition release conditions, limited, much more limited than the courts can. And actually we fight them to release more people and to use their authority more than they actually do. Sometimes we feel that they don't want to take the responsibility, and they say the court will decide, and we push them to exercise this authority more. Even within the 24 hours, there is a possibility for us to, if we think that this is a ridiculous arrest and there's no, for example, it happens a lot with minors, there's no reason to keep that person even for 24 hours, so we file an urgent request to the court, and we can try to affect the situation through this means.
Начну с того, что признателен вам, что вы остаетесь на своих местах. А если конкретно по сути вопроса, то да, действительно, нельзя сказать, что внедрение этой системы было безболезненным. И прежде всего надо говорить о том, как нам удавалось изменить философию или логику восприятия этих процессов непосредственно в самой полицейской организации. И очевиднее всего самым большим вызовом было именно вот это вот понимание в полицейской организации процессов, которые мы предлагаем. Юридически каких-то особых там предостережений по внедрению этой системы не было. Вот. Но в то же время рутинные вопросы согласования, конечно же, заставляли нас искать какие-то нестандартные решения. Вот. Ну, нам удалось, и я думаю, что теперь перед нами стоит более глобальный вызов, это мультипликация этой системы на территории всей страны, а не только в пилоте. И о ее результатах следует говорить исключительно положительно. Почему? Потому что на сегодня в комплексе с внедрением системы мы внедрили еще несколько решений, которые позволили нам говорить точно о обеспечении прав человека. Тут речь идет о замене полной технической передвижного состава, которым перемещается эта категория лиц, о модульном питании, о медицинском обеспечении и так далее. Вот. Ответ будет, наверное, финализирующий краток. Безусловно, положительно. И будем продолжать дальше. Спасибо.
The question of the confidentiality. Of course, it's a very serious question, and in Austria, basically, the law foresees that the police is calling the lawyer on duty, and then this person stays alone in the room and can have this confidential call. Most of the cases that happens, but unfortunately not always. We are aware of cases when the police officer stays in the same room while the person is talking on the phone. We were told by lawyers that they are aware of such cases, and that's why they are always asking at the beginning yes or no questions, and only if they can ensure that they are alone in the room, that then they really can ask also open questions, which is an additional issue and a very big challenge where we haven't yet found a solution is the translation. If people doesn't speak German, how to ensure this confidentiality also in different languages.
Thank you, dear panelists, for your brilliant presentation. I would say thank you for introducing several systems. Thanks for going into deep at some details, and thanks for answering the question. We all agree that early access is important in criminal justice. We all agree that it's crucial. We see that there are challenges, but we see that there are success stories. And these success stories gives us incentive to make system more effective, to work as much as possible in our countries, and increase this possibility of early access. We apologize for disturbing the early access and proper access to the lunch, but we hope that it's better criminal justice early access. We will have small announcement on technical logistics.
First, a round of applause, I think, for our panelists. Thank you, guys.